Major breaking news. We finally have a Donald Trump Solicitor General. John Sauer has been confirmed by the United States Senate today by a vote of 52 to 45. Mission critical. This is the final piece to the puzzle. It was mission critical to have a Solicitor General in the Department of Justice who is the general involving all appellate litigation, including the administration's position before the United States Supreme Court on all issues, including, yes, indeed, the Second Amendment's right to keep and bear arms. Let's break it down when we come back. This is a big deal, folks. Hey, folks, I'm Mark Smith, host of the Four Boxes Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment. Thank you, 2025 Gundies Awards. I really appreciate your vote of confidence. All right, folks, this is a big deal. This is the thing we've been waiting for. This is the moment in time where, as far as I'm concerned, everything should change, and I suspect everything will change. What do I mean by that? As I've been telling you before, that Donald Trump's Department of Justice has been operating not with a full complement of its officers, if you will. It has basically been plain short-staffed the whole game to date because the United States Senate had not yet confirmed a Solicitor General of the United States. Today, that has now changed with the Senate confirmation in a 52 to 45 vote in favor of John Sauer, who has now been confirmed as the next Solicitor General of the United States. This is a huge deal, folks, because it is the Solicitor General who functions as the head coach over all appellate litigation in federal courts on behalf of, in this case, the Trump administration or any administration, including any White House. And this includes deciding what position to take strategically and which cases to ask the Supreme Court to grant cert on, which cases to argue that it should not be granted cert, and so on. This is a very big job in the federal government. It's highly respected, and it is looked to very carefully by the United States Supreme Court. In other words, whoever is the Solicitor General of the United States has great sway over litigation and, of course, our Second Amendment before the U.S. Supreme Court, and involving all the lower federal appeals courts. As you know, we've seen many instances in the last few months where we're asking ourselves, why is the Trump administration still taking a position that seems anti-gun, that seems anti-Second Amendment, that seems pro-ATF? Well, a big part of that, as I've explained to you, is that the person that ultimately is responsible for making those strategic decisions involving litigation, legal strategy, legal theory, and whatnot is the Solicitor General of the United States. He or she is often referred to as the 10th Justice. There are 9 Supreme Court justices. The Solicitor General is often referred to as the 10th Justice. You can Google that. There's actually books written, I think, with the title The 10th Justice about, indeed, the Solicitor General himself. And as you know, one of my longtime mentors, who's no longer with us, unfortunately, was the former Solicitor General of the United States, Kenneth Starr, who taught me a great deal about constitutional litigation, constitutional strategy, and constitutional law, and dealing with the United States Supreme Court, and sponsored my admission to the U.S. Supreme Court Bar. But I digress. The point is, this is great news today, folks, and up until now, I've been telling the Second Amendment community, look, pause, give the Trump administration a little bit of time to get its act in order when it comes to the Second Amendment. They've already done some good stuff. There's a lot more good stuff coming, I suspect. But give them a little bit of time when it comes to these court cases, because right now they're not operating with their head coach. They're operating with an acting Solicitor General. They're acting with a lot of acting U.S. attorneys. These people are not going to be the people that are going to make the command decision on behalf of an administration to, let's say, change 50 years of interpretation or 50 years of policy positions by the Department of Justice, arguing, for example, that yes, suppressors should be protected by the Second Amendment and taxes on them, for example, would be illegal. So again, the only person, in my view, that has the gravitas and the leverage and the authority and the PR and all these kinds of things that all come together to make a change in position in favor of the Second Amendment and against the gun control movement after all these decades of not just anti-gun liberals and anti-gun Democrats in office, but in many respects, the law and order conservatives, the law and order Republicans have been just as problematic when it comes to our right to keep and bear arms over the many years as well. So the one person that was needed, in my opinion, to change the course of history moving forward was for Donald Trump to get his Solicitor General in office, and that has now just occurred. Now, just to remind you, John Sauer is an excellent lawyer. He's a former federal prosecutor. He was the Missouri Solicitor General for the state of Missouri. He's successful. He represented Donald Trump and is the lawyer that successfully argued in the U.S. Supreme Court against Jack Smith and successfully won the case that said that President Trump had presidential immunity from many of the events associated with January 6th. That was a major win that shut down the Jack Smith nonsense the summer 2024, right before the election. That was brought about not just by the U.S. Supreme Court, but also by the excellent argumentation and work of John Sauer, who at the time was representing President Trump. Now, John Sauer is the Solicitor General of the United States and should be, and I got my fingers crossed and I'm cautiously optimistic, will be representing, among other conservative concepts, the right to keep and bear arms. Because if you're an originalist, and John Sauer certainly should be that, given the fact that he clerked on the United States Supreme Court for none other than Justice Antonin Scalia, the ultimate originalist. And again, the notion of originalism is you look at the text of the Constitution, you understand what the text of the Constitution meant when it was adopted, and you don't allow modern day judges to make stuff up because they think it's good policy, because that invades the role of the legislative and the elected officials, and we the people. You want judges to apply the law as it was enacted, as it was understood, when it was enacted, when it was entered, whatever it is. And that is, I think, where John Sauer's mind is. And I am highly confident that he is going to do a great job advancing the Trump administration's views before the United States Supreme Court and in all the courts of appeals. And this is key. The Solicitor General doesn't just set the policy and set forth the arguments in the U.S. Supreme Court. He is also responsible for setting forth the policy and the legal positions to be taken by the administration in the lower courts, specifically the courts of appeals. So when you let's just look around the kind of the landscape right now of the courts of appeals cases that touch fingers with the Second Amendment and could be something that John Sauer gets involved with. For example, we know right now that the U.S. Court of Appeals for the Third Circuit out of Delaware, Pennsylvania, and New Jersey has that very powerful, I think it was 11-2 or 13-2 decision in favor of the Second Amendment in the Bryan Range case that says a nonviolent felon cannot be disarmed for life. Now, there's no decision yet by the Trump administration as to whether or not they're going to seek cert in that case to try to get the U.S. Supreme Court to grant cert in that case and affirm, if you will, the Third Circuit viewpoint, which is what I think they should be doing. I don't know what they're going to do, but I think that's what they should be doing. That is the decision I suspect that will be made by John Sauer, the now official formal Solicitor General of the United States. Likewise, we have the Reese case against Merrick Garland, Reese versus Garland, which I guess now is Reese versus Bondi because you swap out the name of the Attorney General when you swap it out. It's no longer Garland, is no longer the Attorney General. Pam Bondi now is, so these case names are going to change. So the Reese versus Garland case or Reese versus the United States case should now become Reese versus Bondi or Reese versus the United States. And now the Reese case, as you know, deals with young adults. This is that ATF regulation and that statute that says that 18, 19, and 20-year-olds are not allowed to acquire handguns from federal firearms licensees, which is kind of odd because under federal law they can buy guns out of their buddy's back of a trailer, but they can't buy it from a gun store. Kind of stupid. But anyway, that's the position of the current law. That's what the law is. And again, this is another example where John Sauer, as the Solicitor General, could step up and say that we agree that the Fifth Circuit's decision in Reese that says that 18, 19, and 20-year-olds have full-blown Second Amendment rights is the right answer, and they could seek cert. I call it doing the Windsor, where you do what Obama did in the gay marriage context, where he sought cert on behalf of the gay marriage people, saying that we think the Supreme Court should resolve this, but we're going to continue to enforce the law against the gays, against the gay married couple, against the domestic couples, whatever it was there, on the grounds that we're going to continue to enforce the law. So they're still standing. You still have Article 3 standing, and you still have a case in controversy, but we, the Obama administration, are going to argue in favor of the gay couple. And that is exactly what John Sauer, the Solicitor General, in my view, should do here for the Trump administration involving the Second Amendment cases. That involves not just the Range case out of the Third Circuit dealing with nonviolent felons, but again, also the Reese case dealing with 18, 19, and 20-year-old adults and whether or not they have full-blown Second Amendment rights. To me, the right answer in both of those cases is that the Solicitor General should seek cert on behalf of the United States. They should tell the Supreme Court, we're going to continue to enforce these federal laws. If you get caught doing something improper, we're going to put you in prison so they're still standing. You have a case or controversy in existence on Article 3 to make Chief Justice John Roberts happy and not to kick the case out on mootness or something like that. And you make that position and you say that once the court grants cert, you're going to flip sides and you're going to defend and argue that indeed you think the Second Amendment trumps these federal gun control laws. And that is exactly what I think should happen both in the Range case in the Third Circuit and the Reese case down there in the Fifth Circuit, which covers Texas, Mississippi, and of course, Louisiana. I also think, of course, we know what's going on in that Peterson case dealing with suppressors. We've talked a lot about suppressors. In fact, I just had an article. I need to try to do a video on this. Believe it or not, I know you're going to find this shocking. It's not an April Fool's joke. It's actually true. I'll put a link to it somewhere. I already posted it on X. I published an article in Bloomberg Law. That's right, Bloomberg Law. Actually, it did quite well. Got a pretty big number of people read it for a Bloomberg Law piece. I think people seemed to be happy with it. Anyway, I argued about the Fifth Circuit panel had screwed up the suppressor case in Peterson and how the Trump administration and the full Fifth Circuit should step up and fix this. And this is something that I think the Solicitor General John Sauer can also be advocating for, to tell the Fifth Circuit Court of Appeals they gotta flip the Peterson three-judge panel, which screwed up the suppressor argument entirely, even finding the suppressors are not protected arms. They're not textually arms under the Second Amendment. Totally crazy, clearly wrong. And I think John Sauer, the Solicitor General, has the authority and, again, the gravitas to go down to the Fifth Circuit and basically argue for a change of position. Now, the only other three things, I don't want to say these are long shots. If I were the Solicitor General, I would likely do it, what I'm about to say, but I don't know, where John Sauer is, because remember here, I just want to step back 1 second here. Remember, John Sauer is also going to be the lawyer in the U.S. Supreme Court for the next several weeks, arguing all these crazy D.C. deep state fights over the Alien Enemies Act, over deportation rules, over whether or not you can get rid of the USAID, over whether or not you can, Donald Trump can fire these people on these panels and these committees and these conferences and on and on and on. All that craziness going on in deep state where all these people are trying to stop Trump from effectuating his agenda. They want to cling to their jobs for the federal government. I don't blame them, because they're probably really easy jobs and pay really well, so I kind of get where they're coming from. But nevertheless, Donald Trump is in charge of Article 2, the executive branch. He should be entitled to run it as he sees fit. It's his branch, and he was elected as the president from which all the power of Article 2 derives. Nevertheless, remember, John Sauer in the Solicitor General's office is going to be heavily involved with all those types of cases, so it's not like they can devote 100% of their time to the Second Amendment. So just keep that in the back of your mind. He's going to be drinking from a fire hose really quick. I'm sure he already is as of this moment, now that he's just been confirmed. But with that said, I do think if I were running the Solicitor General's office, if I'm the Solicitor General, I would probably want to submit at least letters on the docket to the U.S. Supreme Court in 3 pending cases involving the Second Amendment arising from state law claims, state fights. One, of course, is the Worth versus Minnesota case. This deals with 18, 19, and 20-year-olds. If you remember, there's a rule out there, a law out there that was struck down in Minnesota that restricted the ability of 18, 19, and 20-year-olds to be able to get concealed carry licenses to carry guns at those ages. And that was struck down by, the district court and then by the 8th Circuit reaffirmed that, as I recall. And now that is up on cert, as I recall, in the Worth case. Both parties, both the petitioners and the respondents, are urging the Supreme Court to take a case and decide whether or not 18, 19, and 20-year-olds have full-blown Second Amendment rights. If I were the Solicitor General, I might consider submitting a little document saying to the Supreme Court, now that I've just been confirmed, I would like to let the court know that the Solicitor General's official position is you too should grant cert in that Worth versus Minnesota case, because really it's a layup to have 18, 19, and 20-year-olds have full-blown rights, since they're full-blown adults today, unequivocally including the full-blown right to vote, as we see in, I think, the 26th Amendment. And of course, you know what I'm about to say, I would seriously consider, if I were the Solicitor General, put in a respectful submission to the Supreme Court urging them to take both the Snope AR-15 semi-automatic rifle ban out of Maryland. I would say, look, the time has come. You got too many courts are messing this up. It is clearly they're not applying the Heller in common use test. We're not asking for any kind of exotic relief here. This is the most popular rifle in the history of America. It's certainly the most popular rifle today, the AR-15 and semi-automatic rifles. It's what everybody and their brother has, and the fact that some states are trying to ban this is simply outrageous. I would say to the Supreme Court, if I were the Solicitor General, just get it fixed once and for all. Stop messing around with it. As to the Ocean State Tactical, this is a little bit closer call. The reason why I say it's a closer call is that Ocean State Tactical is on an interlocutory appeal. That was a decision on a preliminary injunction, and it involves magazines, which I just think is a little bit more conceptually complicated for judges and justices that are less familiar with firearm technology. So I know it's an easy layup from our point of view, but if I were the Solicitor General, I would probably push them to take the Snope case, which is on a final judgment out of Maryland. It's a straightforward AR-15 semi-automatic rifle ban case. It's an easy case. The answer is obvious. I would probably push that one, and I would probably urge the Supreme Court to hold in abeyance the magazine cases such as Ocean State Tactical and conceivably Duncan if it goes up there and the like. I think I would probably ask the court to hold those and not grant cert on those as a strategic matter. But again, that's a kind of a line call. I could be persuaded either way on that, but I'm just telling you from my perspective here, I think the magazine cases are a line call with the Supreme Court. We might be better off getting a clear, unequivocal victory on AR-15s and semi-automatic rifles, and then down the road, turning our attention to getting a grant in a magazine ban case. So there you have it, folks. But this is great news. Bottom line is we have a Solicitor General of the United States. Donald Trump has a great lawyer. I think this is going to change things dramatically because I think there's a lot of institutional inertia that was going on. And I think John Sauer, as the Solicitor General, is going to be able to break through that because he now has, again, the gravitas and the authority and the legal position to be able to make these decisions. And I suspect there was a lot of people waiting to see what was going on, to see what John Sauer thought about these big ticket constitutional items. I understand the logic behind it, but now is the time for them to start the act. There is no more excuses given they have a Solicitor General, and that is the go-to guy for any presidential administration when it comes to Supreme Court litigation and federal appellate law. So there you have it, folks. Hope you learned a little bit something here today. Hope it wasn't too geeky. Make sure you follow me on X at 4boxes. Don't forget to subscribe, both to YouTube and Rumble, and I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.